Hello, and welcome to this webcast by the Scottish Law Agents Society. I'm going to be speaking to you about that form of civil procedure known as reference to oath. It's an unusual area of law, and I suspect that it is not a topic that you will find covered in any depth, or at all for that matter, anywhere else. The webcast is provided to Scottish Law Agent Society members only, and it qualifies as CPD. Now, this webcast, and indeed all of the webcasts that we will be providing, uh, they are not restricted by any means of passwords or anything of that nature. And the fact is, it can be viewed by anybody at any time. 3 o'clock in the morning, if anyone feels so inclined. But to qualify as CPD, SLAS has to verify your attendance, and that will be done only if you're a current member. So if you do want your CPD, as well as looking to learn all about reference to oath, then if you're not a member, can I suggest that you become a member and then watch this, and then you'll qualify for your CPD. Now, by way of introduction, my name is Andrew Stevenson, and I'm a solicitor advocate, and I'm a partner in the Glasgow-based firm of Hennessy Bowie. I'm predominantly a civil court lawyer, and since about 1992 I've been conducting proofs, debates and appeals in pretty well all types of litigation in the Sheriff Court, and I've also appeared in a proof in the Court of Session. I'm a contributor to Green's Litigation Styles and Green's Civil Practice Bulletin, and I've written articles that have appeared in the Law Society Journal, as well as the Law Agents Society, Scottish Law Gazette, and I've given talks on various topics over the years. Most recently, just before lockdown, I gave a 2-hour talk on how to conduct a Sheriff Court proof. And the reason that I thought I would speak to you on this topic of reference to oath is that, unlike a lot of practicing court lawyers, I do have direct experience of it, albeit that was some number of years ago. I conducted a hearing on a reference to oath in 1996 in a case that was raised before but which was disposed of after the commencement of the requirements of writing Scotland Act 1995, which came into force on the 1st of August of that year, but which didn't affect existing actions. So if a court action were pending at that time on that date, it would continue to be governed by the 1995 Act. Now, the 1995 Act, as I'm sure you know, is of monumental significance, not just in relation to what I'll be talking about, but in relation to proof of deeds and so on. In broad terms, the 1995 Act abolished the whole concept of reference to oath. But as I'll go on to explain, it is a bit more complicated than that. Going back to the purposes of this talk, if you are seeking CPD for this talk, you do of course have to satisfy the Law Society that the contents of this webcast are relevant to your practice. It can't just be on an obscure and obsolete topic. However, my view is that if you are involved in any way with civil court work, then the contents of this webcast will be relevant to your practice, because quite simply, the whole concept of reference to oath is something about which you should have some knowledge. In the course of this webcast, I'll be referring to a number of sources and authorities. Firstly, there'll be some references to the institutional writers. So that'll be Stair, but I'll not spend too long on him. You'll be glad to know he can be rather heavy going, but I'll refer to Stair, Bankton, Erskine, and also Bell. I'll also be referring to various books on court of session practice, books by Shand, by McLaren, and by Maxwell. I'll also be referring to some books on sheriff court practice, which will be an early book by Dove Wilson from the 1890s, Walker, Sheriff Dobie from the 50s, I think, and also McPhail. I'll also be referring to Walker's book on evidence, because there's a fair bit in there about this topic. And I'll also be referring to various cases. The ones that I've noted here for present purposes are Clark's Executrix versus Brown, Royal Bank of Scotland against Malcolm, McAleven versus McCollin's Executrix, the Accountant of Court against Jesse Mackay, and Keddie versus Rickard Goldsmith. Some of these cases are reported in SLT, some are available on the Scottish Court's website. I'll also be referring to the ordinary cause rules, and also some books of styles, one by Wallace, one by Lees, and Bennett's book on sheriff court styles. I'll be referring to a couple of textbooks by Professor David Walker, and one or two other authorities as well. But what I would say is, if you would like a list of these or a note of a particular authority, then if you let me know, then I can provide that quite easily. So, to get back to the talk tonight, or this morning, depending on when you're watching it, as I say, it might be thought that this topic is of historic interest and really no longer of any importance to civil practitioners. And I would disagree with that, really for three reasons. The first one is that the law up until 1995 stated that reference to oath was the only way of establishing many legal dealings, such as loan, gift, and what were termed innominate contracts. So, in my view, you need to know what is meant as a matter of Scots law by reference to oath. And you'll see mention made of it in various textbooks or in various court reports, where you'll see decisions that have been made prior to 1995 and where there's been evidence and there's been a reference to oath. And there's terminology that's associated with this topic as well. For example, you may see reference made, for example, in the first edition of McPhail, you'll see reference made to what's called a proof, habile modo. Now, you may say, what does that mean? Well, it's to do with the restriction of the mode of proof, and I'll come on to that later on, but it's all tied in with this restriction of proof and the requirement in certain cases to establish a case by means of reference to oath. Second thing is that the law of evidence prior to 1995 may be relevant to explain the actions of people at that time, because Because there were restrictions on proof, people may have recorded their dealings and their business in a certain way, and it may explain, for example, why it was considered so important for somebody to get an IOU from a borrower where he or she made a loan. Because the fact is that at that time, written evidence of these matters was absolutely crucial. You couldn't simply rely on parole evidence to prove a loan. The court system, the rules of evidence did not allow that. There had to be written evidence, or you had to resort to reference to oath. The third reason why I think that it's important to know about this is that, and this is a wee bit controversial, but nevertheless, I'll make the point anyway, it is at least arguable that reference to oath is still appropriate in new actions where the court is having to rule on certain events that are alleged to have occurred before 1995. This point came up in a case of mine that proceeded to a proof in Hamilton Sheriff Court, but I'll come back to that later on. Now, technically, and there's no doubt about this, an action that has been raised before the 1st of August 1995 and still remains undetermined, for example, it's been assisted for years, is still subject to the pre-1995 rules about reference to oath. Now, okay, it's unlikely that there's still an action out there which has been persisted for the better part of 25 years. I agree with that. Very unlikely to be any action of that vintage. However, if the matter of reference to oath were purely historical, then in my view one has to ask, why is there still a rule about reference to oath in the ordinary cause rules of the Sheriff Court? If the procedure were entirely obsolete, then one wouldn't expect there to be a rule still within the ordinary cause rules. And the fact is that there is a rule about it, and it's Rule 29.1. There is a chapter in the ordinary cause rules, chapter 29, and it's headed up proof. And the first rule underneath that chapter heading is obviously 1, and it bears the reference to oath. And it provides, and I'll quote this, it says, where a party intends to refer any matter to the oath of his opponent, he shall lodge a motion to that effect. And the rule says also that if a party fails to appear at the diet for taking his deposition on the reference to his oath, the sheriff may hold him as confessed and grant decree accordingly. Now, I can imagine that many civil practitioners, particularly younger civil practitioners, probably skipped past that rule. And the few who have taken the time to read it will probably find it a bit peculiar, might think that it refers to the oath administered to a party before he or she gives evidence as a witness at a proof. You should note, however, though, that the rule does not mention proof and it doesn't mention evidence. And this is because where there's a reference to oath, as I'll explain, there is no proof, there's no evidence, and there's no witness. And I would ask you, if you have to take anything away from this webcast today, you should take away with you the knowledge that reference to oath has nothing to do with proof. The person who takes the oath is not a witness. He or she is a deponent. So this rule exists in the Sheriff Court rules even now. And there is also a rule in the Sheriff Court rules, and it's Rule 29.5, which enables the sheriff to limit the mode of proof. That rule is clearly a legacy of the pre-1995 law on restrictions on evidence and the means of establishing a case. So these two rules undoubtedly refer to the pre-1995 rules about restrictions on evidence. So, getting back to reference to oath, I've trawled through the books on this, and my view is that the best definition of this concept is to be found in Charles Shand's book on practice, the practice in the Court of Session, which was written in 1848 and which contains the following definition. The author says as follows. He says, when a party has confidence in the integrity of his opponent, or when he has no other means of proof, he may refer the facts in dispute to his adversary's oath. Such a reference is a judicial transaction between the parties by which the case is perilled on the deposition to be made. Now, the most important word in there, in my opinion, is the word transaction, because in my view, it best sums up the nature of a reference to oath. And we'll see that word occurring in a number of other authorities. But essentially, where there's a reference to oath, the parties agree that whatever the deponent says is binding. So that's the definition in Shand from 1848. And Shand certainly wasn't the first author to write about reference to oath. Lord Bankton, who was writing nearly a century earlier, says that when an oath is made on the deference of the adverse party, it is a kind of transaction. So there's that word again, transaction, coming up. Transaction that the matter shall be determined according to that issue, so that though the party forswear himself, yet the civil question regularly can never again be brought into judgment. Forswear, as I'm sure you know, just means to swear falsely or to commit perjury. So Bankton is saying here that the party referring the point to his opponent's oath agrees to be bound by the answers given. Whether they're a pack of lies or not, whether anyone believes them, the fact is, where you agree to a reference to oath, you are undertaking to be bound by whatever is said by the person, the deponent who is on oath and answering the questions that are put to him or her. Bell's Principles, this is the 10th edition from 1899, describes reference to oath as the last resource, or the last basically the last resort of a party who fails in or despairs of any other evidence. And he describes it as being ultimate and conclusive. Similarly, in paragraph 22.13 of Walker's on Evidence, this is the 3rd edition from 2015, it's described as a procedure of last resort, used only if parole evidence was not available and no writ was available to use in evidence. Bell says that it is a transaction, there's that word again, transaction, by which the party who refers places the cause on the sole issue of his antagonist's oath and agrees to stand by it as decisive. So, as I say, it's the character of reference to oath as a transaction or a contract which is so important in appreciating what it involves. McLaren on Court of Session Practice, which dates from 1916, has a whole chapter, chapter 16, which deals with reference to oath. And at page 523, the author observes that oath of party is considered and treated as a species of contract, as a quasi-contract, though of a peculiar kind. Certainly is peculiar. He says the oath, when emitted, shall be conclusive of the matter referred. Erskine, and I have Erskine's book up here behind me. This is this book here, Erskine, in his Institute of the Law of Scotland, which is that tome there. He traces the practice back to antiquity. And he says at page 1105 that the Romans considered such oath as a species of transaction, which consequently had the force of a final judgment. So you can see how old this notion is. But it's essentially a contract. I should say at this point too that reference to oath is not simply something that affects a pursuer. It's not simply a requirement of a pursuer that he or she may have to use reference to oath. There could well be cases in which a defender would be compelled to refer a matter to the oath of the pursuer. For example, let's assume there's a payment action and the defender admitted taking possession of the pursuer's money, but claimed that it had been gifted to him or her. The defender in that scenario would have to refer that allegation of gift to the oath of the pursuer. As you'll know, there's a strong presumption against gift, and it was a requirement that proof of gift be by writ, writing, or by reference to the oath of the alleged donor. So I hope that these authorities that I've quoted give you some idea of what's meant by reference to oath. I should say at this point that MacPhail is not a great source of information on reference to oath. I know it's a wonderful book on so much of what happens in the Sheriff Court, but it's not great on this topic. Even the second edition, which was published in 1998, was published only 3 years after the Act came into force, doesn't really say very much about this. And certainly the last edition, which, as at today's date, is the third edition, doesn't say much about it either. I found that much more helpful Sheriff Dobie's book on Sheriff Court practice, and it dates from 1952, I think. He says, for example, page 230, he says, the oath of a party is not, strictly speaking, proof. It takes the place of proof. He goes on to explain what happens. He says that an examination under a reference to oath is conducted by the solicitor of the party who has made the reference. The solicitor for the deponent is entitled to be present but cannot cross-examine. So you see, there's another difference from a normal proof. You can't cross-examine during a reference oath. Although Dobie says that the solicitor may take objection to incompetent questions and may suggest questions to be put by the court. Dobie says that the matter is purely one of construing what the deponent has sworn to, and matters of credibility cannot be raised. So, as I said earlier, this is one of the features of this procedure, that the deponent may be a blatant liar. It doesn't matter. Questions of credibility simply don't enter into the situation. I think I mentioned earlier Dove Wilson on Sheriff Court Practice. Yeah, this book's from 1899, which is the same year as the edition of Bell that I referred to. He says, the only question in the cause is what has been sworn. There is no room for questioning whether the oath is true or false. So you can see what an enormous gamble somebody takes by referring a matter to his opponent's oath. I should say at this point as well that the concept of reference to oath is applied identically in principle to both the Court of Session and Sheriff Court. It's simply a means of putting into effect a principle concerning the admissibility of evidence in general. That, of course, is a matter of the substantive law of evidence in Scotland. The way in which it's applied in the courts is the same. So it's quite legitimate to look at Court of Session authorities in determining how the mechanism applies in the Sheriff Court and vice versa. I should also say at this point that nobody, and you've probably gathered this already, nobody, unless he is completely and utterly desperate, would ever use reference to oath as a means of succeeding in a case. Because essentially you're trusting your opponent to backtrack and essentially admit that your case was right all along. Now, you have to ask yourself, is it really likely that anyone would do that? I doubt it very much. At one time, when people were God-fearing, they might have been scared to commit perjury, and Stair makes the point there that God is an avenger when it comes to perjurers, and that his Institutes of the Law of Scotland was written in 1681, I think. Clearly, in those days, people were scared about God avenging perjury, but nowadays, as we know, litigants don't bother about divine vengeance at all, and perjury, I think, is unfortunately quite a common thing in the courts. In the days of Stair, people took these things, took an oath very seriously. Nowadays, not so much. Stair calls reference to oath an oath of verity, as indeed does Erskine. He also says that the swearer runs the hazard of perjury and infamy if he's telling lies. But that may be right, but ask yourself this: if somebody finds himself giving a deposition under oath, it's precisely because there's no evidence to contradict whatever he chooses to say. So, how is he ever likely to be found out if he's lying? Could happen, but it's pretty unlikely. And I accept that perjury is a criminal offence, but how many times do we ever hear about anyone being prosecuted for perjury? Really? Tommy Sheridan was prosecuted for it. Andy Coulson was prosecuted for perjury. They're very rare cases. So, going back to reference to oath, I should say that reference to oath, or referring somebody, or referring one's opponent to oath, was always an option in pretty well any kind of case. It was just that it was mandatory in some situations. Walker's on Evidence, this is the second edition from 2000, paragraph 2521 says that before 1995, either party to a litigation was entitled to refer to the oath of his opponent. The whole cause or any disputed questions of fact, except an obligatio literis or a consistorial cause. Obligatio literis, as you know, is a contract which requires writing for its constitution. For example, the sale of a house. The common law was superseded by the 1995 Act regarding those types of contract. Consistorial, of course, just means to do with marriage or divorce. So, okay, there were certain exceptions, but generally speaking, you could always rely on reference to oath. But then, of course, you have to say, well, why would anyone ever use that method if they didn't have to? So reference to oath was always quite a rare thing. Certainly very rare by the time of the 1995 Act. In his book, The Oxford Companion to Law from 1980, Professor David Walker states that reference to oath is, in Scots law, a form of proof. No, it's not a form of proof. Whereby a litigant may require his opponent to answer on oath as to the truth of his case or some specific part of it. By referring the matter to his opponent's oath, challenge or contradiction of the answers given is incompetent. It is in effect an appeal to the opponent's conscience. Very true. He goes on to say it is now uncommon. Well, apart from the claim that it's a form of proof, this is a very good description. And it's no wonder that it was uncommon in 1980. My recollection is that it was certainly uncommon in the years leading up to the 1995 Act. In the summer of 1988, I worked for a big law firm in Edinburgh and went to the Sheriff Court a lot and went to the Court of Session quite a few times as well. And some of the rules around then were quite arcane. The Civil Evidence Scotland Act 1988 wasn't brought into force until the following year. So there were still rules around about corroboration and about hearsay in civil actions. I started my traineeship in 1989 in Glasgow and attended Glasgow Sheriff Court a lot from that point onwards. And I started appearing there in 1990. And at that time, there were a lot of practices which are now no longer in existence. Causes had to table in the Sheriff Court. And when it came to written pleadings, cutting and pasting meant literally that, although you tended to use a stapler instead of paste. So there were a few strange rules around at the time. However, I don't remember reference to oath being used at all. Obviously, it was required in certain cases. It was competent, but you would hardly ever come across it. It would probably be something you would come across if your opponent didn't really understand the full implications of it. So at that time, as I said earlier, certain matters had to be proved by this method. Gifts, loans, apart from very small loans, innominate contracts could only be proved by reference to oath or by written evidence. Now, in my opinion, there was actually some sense in this, because what it meant was that if you chose to lend money to somebody and you wanted to make sure you'd get it back again, you made pretty sure that you had written evidence, because you knew that if you didn't have written evidence, you were pretty well stuffed if the borrower chose to deny that he or she had received money from you. So you'd get an IOU. If you received a gift from somebody, it was always a good idea to keep a letter, card, or something of that nature, just to show that it was a gift. You also knew at that point that if you didn't have written evidence, probably wasn't much point in suing somebody at all, because you'd have to rely on that precarious last resort reference to oath. Some may think that was harsh, but if you were aware of the law, then you knew at the time that you had to get something in writing. Not that difficult. So that was the situation then. I said at the outset, I think that my qualification, such as it is for speaking to you on this subject, is that I undertook the defence of a case in which there was a reference to oath. And without breaching any duty of confidentiality, I can tell you that the facts briefly were as follows. Two women were in or had been in a same-sex relationship. The elder of the two was wealthy, but she was habitually inebriated, and she was poor at managing money, and that included her own money. Now, she said that she'd fully acknowledged that at the time. She knew she couldn't handle money. She was drunk all the time. She would squander it. And her solution was that to ensure that she didn't blow all her money on alcohol, she entrusted the money to her younger companion. So she gave custody of the money to her partner on the basis that it would be fed back to her moderately as her reasonable needs required. So reasonable needs would be clothing, food, toiletries, but not gin or whiskey. And none of this was done by any bank transfers or standing orders or direct debits or anything like that. It was done by the older partner taking out large sums of cash and handing them over to the younger partner. Now, the significance of that, obviously, is that there were no bank statements to vouch the transfer of money between one partner and the other. And it didn't matter, this all went swimmingly at the time, until, of course, it started falling out. There were arguments, there was bitterness, acrimony, and eventually they split up. Now, in those days, in the 1990s, same-sex couples who split up had to resort to various legal concepts such as unjustified enrichment, constructive trust, that kind of thing. You know, these days we've got the Family Law Scotland Act 2006, Section 29, Section 28. These things are a lot more flexible, but in those days it was a bit more difficult to deal with same-sex partners who had split up or where someone had died. Anyway, in this case of mine from 1995, 1996, the elder partner claimed that at the time of the separation, the younger partner was left in possession of a large sum of her money. The younger one denied all this, said she'd never had any money from her companion at all, and got to the point where the elder one decided to raise an action, which she did. She raised a payment action in Glasgow Sheriff Court. Now, the action was raised in 1995, but it was raised before the 1st of August of 1995, which was the date on which the Act kicked in. And she sought repayment of what she claimed had been a loan. She could have framed her case on the basis of trust, something of that nature, but she chose to say it was a loan of money. And as I say, significantly, there was nothing in writing to vouch the pursuer's claim. There was nothing by way of a bank statement to show her erstwhile partner's receipt of money. There was nothing in writing to prove the nature of the agreement that was said to be in existence. Nothing at all. And with hindsight, indeed with foresight, this was a big mistake on the part of the elder of the two partners. Because essentially what it meant was it was her word against that of the other. It was the other who I acted for, by the way. I acted for the younger of the two. These days, in a situation like this, it's reasonably straightforward in terms of what happens. The parties would each go into the witness box, take the oath or affirm. Each would give parole evidence, challenged under cross-examination about credibility and reliability and so on. And the issue really would be what had happened or what hadn't happened. After the evidence had been given, the sheriff would then assess the evidence and would decide who he or she believed and would make a decision based on that. That's how it would work now, obviously. But this case was commenced before the 95 Act, and so what I've just described did not happen then, could not happen. The law didn't allow that. Because it was a loan and because it was more than the minimal amount that was stipulated as being the figure that above which there had to be a restriction, it had to proceed by writ or oath. The figure at that time, by the way, was £8.33, I think it was, which was the sterling equivalent of the old £100 Scots. So if you lent money if you lent a fiver, for example, you could prove that by any means. But if it was more than £8.33, had to be by writ or oath. And I can't remember how much money was involved in this case of mine, but it was a lot more than that. It was a 5-figure sum from memory. In any event, in my case, because there was nothing in writing to vouch what the pursuer was saying, the pursuer had to refer the matter to my client's oath under one of the rules that I've already referred to, which is Ordinary Cause Rule 29.1. Before going on to say more about the case of mine, I should perhaps say something about terminology, because this is something that I think I mentioned earlier on, where there can be different types of proof referred to. You'll see this sometimes in the old court reports. Now, if you think about it, there can be essentially three types of situation here. A proof, any proof, is only concerned with the contentious parts of an action. So if something's admitted on record, that doesn't go to proof. Similarly, if there's a joint minute of admissions, it doesn't go to proof. That's the whole point of a joint minute of admissions. And if you serve a notice to admit, which isn't answered, isn't challenged, then whatever you've put in there doesn't go to proof either, because it's deemed to be admitted. So a lot of what's in the pleadings isn't contentious, or it ceases to be contentious by the time of the proof, and the proof is concerned only with the bits over which the parties are arguing. So the proof can really be concerned with three situations. Firstly, you can have a situation where I'm talking now about pre-1995. You can have a situation where none of the contentious matters are provable by normal means. In that situation, the whole proof, the entirety of the proof, would be concerned with matters where there is a restriction. So there would be a restriction to proof by writ, by writing, or everything would have to go to a reference to oath. Everything that was disputed. So that's one situation. You can have a second situation, probably a more normal situation, where different parts of the case would have to be proved by different means, or established by different means. So, for example, contentious facts in my case, say there was a dispute about when the parties had separated. Now, there wasn't a dispute about that. But if there had been, that could have been proved by any means. The bit that had to be proved by reference to oath was the loan. That was the only thing that was in dispute. But if there had been different things in dispute, the different things might have been provable by different methods. And in that situation, you would have a proof by, and it was called a proof habile modo, which is simply a proof where different parts of the case would have to be proved or established differently. That wasn't the situation that I had. The third situation, and it's the one you get nowadays really, is where everything can be proved by normal methods. And in that case, the proof was said to be a proof prout de jure, which some people I remember used to pronounce prou de jure, but it's spelled Proutdejure. That is a normal proof. So there are these three possibilities, and for that reason, I think we still have this rule in the ordinary cause rules I've referred to already, Rule 29.5, which is the rule that says that the sheriff may limit the mode of proof. So the mode of proof is the way in which the facts are proved. Sheriff McPhail's book, 2nd edition, which is edition immediately after the 95 Act, says that all proofs are now proofs prou de jure or prout de jure. And the 3rd edition from 2006 says at paragraph 856 that Rule 29.5 is no longer applicable. That's a rule that says the sheriff can restrict the mode of proof. McPhail says that's no longer applicable, which begs the question, why is that rule still in the rules? McPhail was saying that in 2006. And if that were right, you'd think that rule would have been taken out by now, but it's still there. So as I say, in my case, the only contentious averments were in relation to the alleged loan. So we had the first scenario that I've mentioned, which is the one where everything was restricted. So in my particular case, what I did was I put plea in law into the defences in the what was then the conventional form, which was that proof of the cause should be restricted to writ or oath. Now, the authorities, they don't mention the necessity of including pleas in law directed at referring one's opponent's case or part of it to oath. But the practice, certainly in the 1990s, before that, was certainly to do that in the Sheriff Court. I don't know about the court session, but certainly the practice in the Sheriff Court. And reflecting that, the 1989 edition of Bennett's Sheriff Court Styles contains the following plea in law. Now, I'll tell you what it says. It says the defender's averments in answer to being provable only by the writ or oath of the pursuer, proof should be restricted accordingly. So that was the style that he put in his book of styles. The fictional case which he uses there is one that demonstrates that, as I said earlier, it wasn't just a pursuer who would, in some scenarios, have to refer a matter to the defender's oath. There could be situations where the defender would have to refer a matter to the pursuer's oath, and one of them, and it's the one that Bennett uses, is a situation where somebody admits having received a loan, but claims to have repaid the loan. In that situation, the repayment of the loan was provable only by writ, or only by reference to the pursuer's oath. So, say in my case, my lady had admitted borrowing money, but say she claimed that she repaid it to her partner. If that had been the case, the matter of repayment would have had to have been referred to the oath of the lender, who would essentially be the deponent, who would have to say, or would almost certainly not have said, that she had received repayment of the loan. But of course that wasn't the situation. My lady in that case denied having received any money, which is why it was the pursuer that was on oath. So going back to my case, I put in this plea in law, seeking to restrict the case to writ or oath. Now, it's not a very elegant way of dealing with it, but you have to remember that at that point, I had no idea of what evidence the opponent possessed. I had no idea. I didn't know whether she had something in writing, or she might have been able to locate something in writing by the time of the proof. I don't know. I didn't know at the time. So it wouldn't have been appropriate for me to have sought to restrict the case to the oath of the opponent, because for all I knew, she had something in writing. So the plea in law that I stated was really the best I could do. What it did, I suppose, was it put the onus back on the pursuer to decide how she wanted to, or how she had to, I suppose is more accurate, how she had to proceed. Now, the case, as I said, is from 1995, so it was governed by the 1993 Ordinary Cause Rules, which provided for options hearings. And the options hearing took place. Neither party was looking for a debate, so the next step, if you like, was a proof, to use that term loosely here. And the sheriff had to decide whether to sustain or whether to repel the plea in law that I've mentioned, seeking restriction of the mode of proof. Clearly, that was the options hearing, if you like, was the time at which that had to be done. And the sheriff asked me whether a Rule 22 note was required to support my plea. I hadn't lodged a note. As you'll know, Ordinary Cause Rule 22 states that where a party fails to lodge a note supporting a preliminary plea, the party is deemed no longer to be insisting on it, and the plea will be repelled. So obviously the crucial question here is a plea in law seeking a restriction of proof to writing or a restriction to a reference to oath a preliminary plea? Well, the answer to that is it's not a preliminary plea. And that being the case, there is no necessity for a Rule 22. I remember having some discussion with the sheriff at the options hearing about this, and what we really discussed was that what we were concerned about was the admissibility of evidence, which is a topic, if you think about it, that has nothing to do with the pleadings. As far as a preliminary plea is concerned, McLaren on Court of Session Practice says, page 379, that a preliminary plea does not touch the merits of the case. And Dobie says that a plea is preliminary where, when it's sustained, it renders inquiry into the merits of the cause unnecessary. So really you're concerned with the merits of the case, and a plea seeking to restrict the mode of proof has got nothing to do with the merits of the case. So the plea, this plea that I mentioned, which is not a preliminary plea, did not need a Rule 22 note. So it was sustained, and the pursuer's case was restricted in terms of the plea. Restricted in that it required the pursuer to proceed by means of proof by writ or by reference to the defender's oath. So clearly the ball was back in the pursuer's court there, as in what to do next. And the pursuer was left to enrol a motion in terms of Ordinary Cause Rule 29.1. Before I go any further, I should say something about whether or not the court has any discretion over whether to allow to grant a motion to restrict proof by writing or by reference to oath. Dobie says at page 230 that the court does have discretion to refuse a reference to oath if obvious injustice would result, but goes on to say that a litigant should not be deprived of this privilege to refer a matter to oath unless in special circumstances. There's also authority that a court has got discretion over this matter in McLaren at page 524, and also in Maxwell on Sheriff Court Practice at page 319. So, in theory, yeah, there is discretion over it, but I think in practice, it's not discretion that would ever be exercised in favour of refusing reference to oath. So, as I say, in my case, the onus was then on the pursuer to decide how to proceed and how to enrol a motion, the terms of the motion to be enrolled. There are some older textbooks which contain styles about this, about how a motion of that nature was to be framed. They refer to it as a minute rather than a motion, but it's the same thing in practice. And in the textbooks that I've looked at, there are some styles. So, for example, in Sheriff Wallace's book, the style book from 1911, we find the following: that the pursuer refers the cause to the oath of the defender. And we find the defender refers the defence set forth in answer, whatever, to the oath of the pursuer. Clearly, the difference between those two is, apart from the fact one's the pursuer, one's the defender. The first one, referring the cause to the oath of the defender, that's the entire cause being sent to that mode of proof. Whereas in the second type, it's part of the case, so it's a proof habile modo. The styles that are used in Sheriff Lee's book from 1922 are both in respect of proofs habile modo as well. One of them says, the pursuer refers the averments made by him in the fourth article of his condescendence to the oath of the defender. I don't know what the averments are in the fourth article of condescendence, but clearly there's something there that has to be proved or established by oath. The other style he uses here is the pursuer refers the fact of whether the goods in question were ordered by the defender to his oath. Bennett, his book of styles from 1989, contains the following: Cuthbert for the defender refers the averments made by him in answer to the oath of the pursuer. In that instance, it's to do with repayment of a loan. As I said earlier, it would also cover a situation where the defender alleges gift by the pursuer. So these are the styles that were around, and the pursuer, in my case, put in a motion that was in that kind of style. The pursuer could, of course, and in my view should, really have thrown in the towel at this point, because it was clear by this point that she had no written evidence and was going to have to rely on a reference to oath. To my mind, she should have realised that was futile. But then, bear in mind, she and the defender had been in a relationship. She knew the defender better than I did, better than her own lawyer did, so it may be that she thought my client would concede that she had received money by way of a loan. I don't know. I'll never know. But it struck me that it was not going to end well for the pursuer by proceeding in this way. But anyway, undaunted, she enrolled the appropriate motion, which was unopposed. Obviously, I wouldn't oppose that, given that it was to my client's advantage, and the cause was then referred to the oath of the defender. So this took place maybe a few weeks after the options hearing, when the record had been closed, and as is always the way, there's a delay before getting a hearing. And we had a hearing a couple of months thereafter, so this would have been 1996. And the hearing took place in a proof court in Glasgow Sheriff Court. A proof court open to the public, and in many ways the hearing resembled a proof, but it wasn't a proof. The presiding sheriff was Sheriff James Murphy, and what happened was that there was a shorthand writer there. The defender, my client, went into the witness box. She was put on oath by Sheriff Murphy, and she then gave her deposition. Now, this was simply by way of the pursuer's agent asking her a series of questions. That was the format that was used. That's the format that's prescribed by the textbooks, and it was used in this case. So she was asked a set of questions, and she said, amongst other things, that she had never received any money from the pursuer. At this point, the pursuer's agent began to challenge the defender's statement and sought to put it to her that she had in fact received money. Now, at this point, I objected, which I was entitled to do. I couldn't ask questions of the deponent, but I could object to incompetent questions asked by the opponent's solicitor, which is what I did. So I objected to that question, which was essentially a question challenging the veracity of the statement given by the deponent. And the sheriff upheld that objection. So clearly, Sheriff Murphy knew, as the solicitor clearly did not know, that the deponent's statement had to be accepted pro veritate. Dobie says questions of credibility cannot be raised. Same with questions of unreliability, they can't be raised either. My right to object to incompetent questions is something that's clearly covered in the textbooks. McLaren refers to it, Maxwell refers to it, and although I didn't have to do this, I could have suggested questions to be put to the deponent by Sheriff Murphy. Dobie says that the deponent's lawyer cannot cross-examine, but can suggest questions to be put by the court. Well, I didn't have to do that. The whole thing took less than half an hour. Took about 20 minutes maybe. And at the conclusion of the hearing, the sheriff heard very brief submissions. Walker, in chapter 9 of his 1932 book, Digest of Sheriff Court Practice, says that the deposition is conclusive. No further evidence on the matter referred being competent. The only question is the true construction of the deposition. In other words, what did the deponent say? Well, in my case, she said she had not received any money from the pursuer. She couldn't have been any clearer about that, so there was no scope for trying to interpret what she'd said. What she said was unambiguous, and it was clear, and there was no scope for any error. So that was it, and the sheriff then granted absolutor and awarded expenses in favour of the defender. Now, I kind of thought that would happen. It seemed obvious to me that would happen. I think, though, I thought this at the time, to my mind, the pursuer's solicitor's ill-fated attempt to attack the defender's account demonstrated, I think, a misunderstanding of the nature of that hearing. And I think that he thought that this was essentially a conventional proof, albeit one restricted to the evidence of one individual. And I think that had he realised that the defender's account would be binding, if you remember, we referred earlier to the whole thing being like a transaction, an agreement to be bound by whatever was said by the deponent. I think if the solicitor had realised that, he would not, or he would have advised his client not to bother proceeding any further. To me, it was futile going ahead with that hearing, and it demonstrated, I think, it demonstrates now why references to oath were so uncommon. As I said earlier, in exceptional circumstances, the deponent might refuse to commit perjury due to a fear of God, or might feel overwhelming guilt at having to stand in a witness box and support a case based on falsehood. But otherwise, I think deponents are invariably going to stick to whatever is in the written pleadings. I mean, for one thing, doing anything else admits that the court has been misled by the deponent's case on record. So I suppose it's safer to stick to whatever's in the pleadings. And that's what people do. I've only ever had a case once where it was a witness came to me afterwards to say that he lied on oath. It was a case in the employment tribunals involving a matter which was of peripheral significance to the case, but where my witness, I think, was caught on the hop, told a lie, and would have got away with it. But afterwards, he phoned me up in the evening and said he'd lied and that he felt terrible about it. And I had to tell the tribunal chairman the next day that this had happened. And the witness, of course, found that his whole testimony was essentially disbelieved. But there weren't any other consequences. He wasn't, as far as I'm aware, he wasn't reported for perjury. Nothing happened. But at the time, I remember thinking, why did he tell me? He didn't have to tell me. He would never have been found out. And the only answer, I think, could really only be that he felt, as he said at the time, he felt guilty about it. His conscience was bothering him that he had lied. So, whilst I'm maybe being cynical in saying that people commit perjury all the time, not everybody does. Some people have got a conscience and don't want to tell lies, and it could be that reference to oath might work in some cases, but I certainly wouldn't want to peril a case on it. So that was my case. Reasonably straightforward in terms of the procedure. It was simple in the sense that one hearing dealt with everything that was in dispute. To that extent, the matter was simple. But what about disputes where some matters are provable by that means and some matters can be proved by general means? Well, as we've already seen, the appropriate procedure there is for the court, on the closure of the record, to allow a proof, habili modo as it's called. There's a recent case, well, I say recent, I suppose it's that recent now, but it's relatively recent on what's meant by a proof habile modo. It's the Inner House case of Royal Bank of Scotland against Malcolm from 1999. And in that case, their lordship said that proof habile modo simply means proof by the kind of evidence appropriate to each part of the case. And the court referred back to, well, it referred to Walker's on evidence, but also the case of Clark's executrix against Brown, which is a case from 1935, which is reported in session cases that year, page 100. We are at page 119. Lord Murray said that this form of allowance of proof in no way derogates from the rule that proof of loan must be by writ or oath, for it will be the duty of the trial judge to reject parole testimony insofar as directed merely to proof of the constitution of the debt. And the court's view, this is in the Royal Bank of Scotland case, the court's view was that of Walker's, which was that allowing a proof habile modo leaves all questions of admissibility to be settled at proof, or more usually to be reserved. Importantly, though, it remains incumbent upon the party seeking restriction of proof to take that point and in time. Now, what this essentially means is that if you've got a proof habile modo where you've got some restrictions in some areas that aren't restricted, you have to be quite careful about how you prove the case. You also have to be very careful if you're defending the case, because you have to be ready to leap up and object if your opponent is trying to lead parole evidence of something that he's not supposed to lead parole evidence about. In that case, the Royal Bank of Scotland case, the defender had a plea in law as follows. Pursuer's averments anent loan to the defender should be restricted to the defender's writ or oath. Now, in that case, a proof took place in 1995 in relation to loans allegedly made prior to 1995. And it seems, on a reading of the report of that case, that neither side fully appreciated how to conduct the hearing, how to conduct the proof. The Inner House criticised the pursuer's counsel for not understanding or not appearing to understand that he had to prove the loans by writings or judicial admissions, or have the defender and her husband referred to their oaths. So they weren't happy with the pursuer's counsel. Equally, according to their lordships, the defender's solicitor failed to object timelessly when a witness was being questioned on matters which clearly required more than parole evidence. As well as illustrating how a proof habile modo is supposed to be conducted, this case, and you can read the case if you want to on the Scottish Court's website, the case also shows how, even this is more than 20 years ago, court lawyers didn't always have a full grasp of how restricted modes of proof or reference to oath actually applied in practice. I suppose that was an indication of how unusual these things were at the time, but it seems to me that even when it was competent or mandatory to use these modes of proof, lawyers didn't always get it. If I can go back to Rule 29.1 again, which I've referred to a few times, there's something of an anomaly about that rule for a couple of reasons. Firstly, as we've seen, reference to oath is fundamentally different to proof. It's not a proof. It's not a proof of anything. It's clearly a very distinct concept and procedure. So a rule about reference to oath, in my opinion, shouldn't really be found in a chapter headed proof. It should be in a separate chapter. So that's confusing. Having said that, the previous rules, the 1983 rules, Rule 67, which was in virtually identical terms to 29.1, was similarly categorised under proof. Incidentally, while I'm on the topic of confusion and terminology and so on, I should say that the phrase that you'll normally find in textbooks is proof by writ or oath, which, in my opinion, is a wholly misleading phrase. Where you see proof by writ or oath, there really should be a comma after writ, so that it reads proof by writ, comma, or oath, or by oath. Or it should read oath, comma, or proof by writ, because proof by writ is a completely different concept from reference to oath. Proof by writ, and I don't know why it's writ instead of writing, because essentially it's proof by writing. Proof by writing is still proof. Albeit using restricted evidence, whereas reference to oath, as I've said before, is not proof of anything. It's not any kind of proof. So there's confusion in the terminology that you'll see. The other reason why that rule is something of an anomaly, and some might say an anachronism, is that it's not even clear. And here I am telling you about this an hour and 20 minutes after I've started this talk. It's not even clear that reference to oath remains a competent mechanism for resolving disputed matters of fact in the sheriff court or the court session any longer. This is because I think the 1995 Act is more than a little ambiguous. Section 11 of the 1995 Act abolished reference to oath. However, as we've seen, actions raised before 1st August 1995 carry on under the old law. And in addition, and this is very significant, I think, Section 14.3 of the Act states that the abolition does not apply to, and I quote, any document executed or anything done before the commencement of this Act. That's what it says. So, what of the current standing or status of reference to oath? The matter is not free from doubt, obviously. The continued existence of Ordinary Cause Rule 29.1 leaves the mechanism open, but that may be designed to cater for actions raised before 1995 and not yet concluded. However, as I've said, is it really likely that there are any such actions out there? Could be, I don't know. But is an action likely to have been persisted for decades? Seems unlikely to me, but I don't know. So why are these rules still in the Sheriff Court rules? Is there any significance to be attached to the fact that there is no equivalent rule in the court session? Well, my view of that is that there isn't any significance to be attached to that. Claren on court of session practice was writing over 100 years ago. Maxwell on court of session practice was written in 1980. and he deals with reference to oath at pages 317 to 320, and nowhere does he refer to the rules of court. At that time, the Court of Session rules were the 1965 rules. He doesn't refer to any rules, but he does make the point, and it's a good point, that many rules in the Court of Session were unwritten rules. McLaren certainly doesn't refer to any rules, and Shand doesn't refer to any either. My copy of Green's annotated Court of Session rules, which I have behind me, it's the 2015-16 edition. Excuse me, that's the edition I have. It doesn't refer to any rules, although it does deal with reference to oath quite thoroughly, a lot more thoroughly than MacPhail does. Again, why is there a reference to oath and the modes of proof in that book, that copy of the annotated rules of the Court of Session, if the whole concept is obsolete? If you look at that book, you'll see at page 250 it says, "A proof habili modo" means that the proof is allowed by the manner competent to each part of the case. For example, where parts of the cause may be proved prout de jure according to law, other parts are restricted. The judge rules on the admissibility or evidence with respect to a restricted part at the proof. Court of Session Rule 21, allowance of proof. It says that probation may be by writ or oath, abolished for causes commenced after 1st August 1995 by the requirements of Writing Act Section 11, or by proof habili modo. It's all rather unsatisfactory, I think. There's no conclusive answer on this. And as I say, I think the problem is the Act. The Act is ambiguous. I mean, you could say, well, the question really is, does Section 14.3 of the 1995 Act require that a pre-1995 event, like a loan or a gift, be provable only by writ or open for reference to oath in an action that's raised now? In other words, if you raised an action tomorrow concerning an alleged loan from 1981, does proof of the loan have to be by writ or by reference to oath, or can it be by any means? The Act doesn't make it clear, and unfortunately, in a sense, there are conflicting authorities on this. So we find a 1997 case, or was reported in 1997 in Scots Law Times, Sheriff Court Reports at page 46, the case of McAleven versus McQuillan's Executrix. Now, that was a case in which there was an agreement that was allegedly entered into in 1984. But the action was raised after 1995. Sheriff Principal MacLeod, QC, took the view that the agreement was affected by the Act, or was not affected by the Act, I should say, and that it had to be proved by the restricted methods because it predated the 1995 Act. So that was his view. On the other hand, there's a case, a more recent case, Accountant of Court versus Jesse Mackay from 2004. It's reported in Scots Law Times 777 of 2004. It's also on the Scottish Court's website. And in that case, Lord Brackadale appeared to take the view that, and with reference to Section 11 of the Act, the present action was raised after the implementation of the 1995 Act. Accordingly, proof prout de jure is appropriate. In that case, there was an issue over the creation of a trust in 1978. So that was Lord Bracondale's view. I can't see any reference in the report, however, to Section 14.3 of the Act. I don't know whether the judge was referred to it or not. The case is an outer house case, of course. It's not an inner house decision. So it's not binding. Neither, of course, is Sheriff McLeod's case. I'm not aware of any binding case on this point, which I think is unfortunate. I had a case in Hamilton Sheriff Court, the name of which is Keddie versus Rickard Goldsmith. The case is referred to on the Scottish Court's website. There was an inner house appeal in that case in 2012, and the report of that appeal was referred to on the website. But I'm not concerned about that for present purposes. What I would say, though, is that there was a debate in that case. In fact, there were two debates in that case, but in the first debate, which was before the sheriff, the temporary sheriff principal, South Strathclyde and Fuson Galloway, I argued that there should be a restriction of proof. But I was unsuccessful because the sheriff principal took the same view as Lord Bracondale. The facts of that case, in brief, were that a lady had died. The pursuer was her ex-husband, and the defenders were her executors, and the pursuer, the ex-husband, claimed that he had lent the deceased over £52,000 years before, and he was suing her estate for repayment. Now, clearly, a reference to oath would have been impossible because the only possible deponent there was the wife. She died. I argued that there should be a restriction of proof to writ. This is on the basis that the loans predated 1995. And in fact, there was a lack of writing as well. There were certain writings, but they weren't really very substantial. So I argued that, and that argument was not accepted by the temporary sheriff principal. And there was a proof at large before Sheriff Small at Hamilton, and we heard a number of days of evidence, during which the main witness was a pursuer. Clearly, the alleged borrower wasn't there to say anything, having died. And at the conclusion of the proof, Sheriff Small found against the pursuer on the basis of his incredibility and unreliability. And what's interesting, I think, is that in his judgment, he clearly took account of the fact that had the pursuer made the alleged loan, as he claimed, he had done so at a time before 1995 when he knew, or should have known, or would have known if he'd inquired, that the law stated that it was not provable. In other words, had he lent the money at that time, you might have expected him to have vouched it in writing. Because at that time, that was the only way that he could have proved it, other than by reference to the oath of his wife, had she been alive. So, in that case, although the pursuer was allowed to give oral testimony about the alleged loan without very much in the way of written evidence, and without the supposed borrower alive there to contradict him, he was unsuccessful. And significantly, the sheriff attached some significance to the pre-1995 Act law and the rules of evidence that existed at that time. So the reason I mention this is to show that you do need to know something about the pre-1995 Act law of evidence, because it can come up now, and it can come up even if you're not restricted in terms of these laws in connection with a current action. So, going back to the textbooks on this point about whether the law, the 1995 Act, restricts or doesn't restrict the mode of proof for pre-1995 Act happenings. If you look at Walkers on Evidence, my view is it's clear from that the authors of that book think that proof of pre-1995 Act events, contracts, and transactions, and so on, should be by means of the law of evidence at that time. So if you look, for example, at the second edition, which is from 2000, paragraph 25.1.2, the authors say, or they refer to the interaction of the restricted mode of proof and the substantive law. The latter was, and still is, designed to promote certainty of contract by concentrating on the parties' writings and the admission of certain evidence only in the form of writ or oath exemplified that concentration. It must be assumed, in law at least, that when deciding how to record their dealings, some parties were aware that the absence of writing might result in proof of the matter as a whole or an element of the matter being restricted. On that premise, it would be appropriate to save the operation of restricted modes of proof in relation to documents or events occurring prior to 1st August 1995, whether this was the true intention of the draftsman. To my mind, they clearly thought that anything that happened before 1995 should be subject now to these rules of evidence that were enforced at that time. By the time of the third edition of that book, on Walkers on Evidence, third edition is from 2015, we had Lord Brackadale's case, and it's referred to at paragraph 22.1.3. But the authors still, in my view, seem to be of the view that proof is restricted. In post-1995 proceedings concerning an event which occurred under the old law. There's a whole discussion of this in Walkers. So paragraph 26.28.3, there's a whole discussion about different opinions. There's an opinion, for example, whereby proof of the contract is a separate matter from the rules that applied to its construction at the time. There's an argument that the old law applies to actings following upon the contract, but not court proceedings for proof of that contract. So it's an interesting discourse, although I have to say that it doesn't really help humble practitioners. I mean, academics can argue about these things, but we have to advise clients. We have to make submissions to courts, and if you make unsuccessful submissions, you can be hitting expenses, and it can be delayed, and you can get into trouble with your client for having advanced an argument that doesn't find favour with the court. There's all these dangers and risks involved. What we really need, I think, is ideally an amendment to that Act to make the point clear. Because, as I say, it's not clear. That's why there are conflicting authorities. That's why there's arguments in the textbooks about it. The Act is not as well drafted as it should be, particularly about something as important as this. So an amendment to the Act would be good. Failing that, what we really need is a ruling from the Inner House or from the Sheriff Appeal Court. And in a way, it's quite surprising that in the last 25 years we haven't had such a ruling. Or at least I'm not aware of any ruling. It would be good to have that, because that would put the matter beyond any kind of argument. There's still time, of course, but as I say, I'm not aware of any definitive ruling on whether proof of an alleged loan or gift from, say, 1990 should be restricted to writ by reference to oath. My own view, for what it's worth, is that it should be restricted. That's what I believe. Really, for the reasons set out in Walker's, that regard should have been had to the rules of evidence at the time of the contract or the dealing. So, as I say, this uncertainty still prevails. And I suppose, in a way, it's another illustration of why you should know something about the pre-1995 Act law. Where it concerns certain types of transactions, as I say, loan, probably the main one, gift, or innominate contracts. Innominate contracts, I should say, are defined by Walker's book on contracts as being agreements which cannot reasonably be fitted into a well-known category to which a technical legal name attaches. So, for example, sale or hire would be nominate contracts. Innominate contracts are contracts that don't lend themselves to being pigeonholed in any way like that. I imagine the scope for innominate contracts is quite wide. Going back to my case, which is really my raison d'etre for giving this talk, it did occur to me at the time, what would have happened if the pursuer in that case had waited until after 1st August 1995 before she'd raised her action? Now, at the time, she could quite easily have done that, because her claim would not have been time barred, and rather than raising the action in the former half of 1995, she could have waited 6 months, raised it at the end of the year, and according to the Accountant of Court versus Mackay case, she would have been entitled to lead any evidence at all of the alleged loan. And I'm sure that had the action been raised 6 months after it had been raised, we would have had a completely different form of procedure. What would have happened would have been that the pursuer would have been able to give oral testimony, and who knows, she might even have won her case. I don't know. We'll never know. But to me, that simply illustrates that it's fairer somehow if the rules applicable at the time of the loan carried on beyond the coming into force of the 1995 Act. Now, you'll be glad to know that I've come to the end of this webcast, and I hope that it has been helpful and that you can go away understanding something about what's meant by reference to oath. Whether you ever encounter this or not in real practice, I don't know. But as I've indicated, it's part of our system, and was certainly enforced until quite recently, and it still has implications now for how things are done, or how things are to be proved, or how things may be proved. So I hope the talk's been useful. I'm conscious of the fact that I've referred to quite a number of authorities during the course of the webcast. And if you would like a copy of those, or if you want me to provide a copy of a particular authority or particular passages that I've referred to, then please get in touch. And if you have any questions, also please get in touch. The other thing I would say, and just to finish, is that if anybody knows of any cases in which this subject has been dealt with, please let me know, because I'd be interested just to know if there are any other authorities on the matter. If you've had a case since 1995 where this point has come up, then it would be useful to know that for future webcasts. So if you do know of any such cases, please let me know. So I've been talking now for about an hour and 3/4, I think. So for CPD purposes, if you would like your CPD, then if you email Scottish Law Agent Society, so the email address is scottishlawagentsociety@gmail.com. You'll be asked a few questions about the webcast just to make sure that you're paying attention. And SLAS can send you verification of your attendance. You'll get an hour and 3/4 CPD. So thank you very much for listening, and I hope that you listen to other webcasts that SLAS is planning on broadcasting. And goodbye.